Heyo, folks! It is time for an update in the Laura Michelle Owens cases, because she has had a number of them over the years. For you who are completely new to this, Laura Michelle Owens is also known as the serial pregnancy scammer out of Arizona. Now, she does have done this in California as well. So for the past, now over a decade, she has fraudulently tried to have men date her, and when they didn't want to date her, she claimed pregnancy with twins. And it's absolutely horrifying what she made these guys go through. Her latest victim was Clayton Eckert, also known from The Bachelor. And had she not gone after him, she might still be out there doing this to new victims. But he fought back vigorously, and now she is facing 14 counts, 14 felonies in Arizona for what she has done. So today we are going, one part is about the California case, what she did to Mike Maricini, and an appeal decision. And the other one is Arizona, where we're going to listen to attorney Gingerass 911 call. When he, let's just wait and see and listen. And with my usual very calm, collective, diplomatic reasoning. Welcome to the show.
Santa Claus, riding in with the winter laws. Santa Claus, streaming live for the roaring masses. Ho, 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 raise them horns, old Judge King in a crown of thorns. Santa Claus, streaming live for the roaring masses. Santa Claus,
All right. So what we're going to look at is the California appeals decision, the California appellate court. Because, okay, we have to bring you back a bit. This is about the Mike Maricini case. Mike dated her for a while in 2014, 2015, something like that. But realized after a while, this girl is an absolute nut job, and broke off. She wouldn't take no for an answer. She faked pregnancy, faked several terminations, where she claimed she terminated over and over and over again, like as a psychological terrorism, a terrorist act against poor Mike. Well, eventually she found a new victim, but that doesn't mean that Laura Owens lets things go. She filed a restraining order against Mike Maricini back in 2017, and he tried to fight it the first time unsuccessfully because, courts like to take better safe than sorry. So they granted her that. And then when she filed for continued a few years later, he didn't put up a fight. He just wanted to get absolutely rid of her. He was then already seeing his now spouse. I don't know if he already had a kid on. Either way, he had moved on completely. She refused, Laura Owens. And this was put to a test now when she tried to get a permanent restraining order Now, this was after she lost in Arizona in the family court against Clayton Eckert. And we already knew that she had many victims. We know about 4, or officially there's 4. There can be a lot more. We simply don't know. And Laura then filed for a permanent restraining order, and this time Mike had help by the tilted lawyer Omar, and they fought, and she lost. So she didn't get a restraining order because finally the California court saw through her and said, oh hell no. She appealed, of course, to the California Appeals Court with an absolute barrage of filings that had nothing to do with what the appeals court actually had. The only thing the appeals court has to do, did the judge do something procedurally wrong? Laura, with the great help of AI and maybe some help of a person we're going to listen to later, filed this appeal, and now the California Appeals Court have spoken. But don't be happy. Well, be happy for because of the result. But Laura has already said that she doesn't care about the result of the appeal. She will file a new restraining order against Mike Maricini. For context, Mike Maricini lives in California. Laura Owens lives in Arizona. Mike Maricini has not contacted her voluntarily since 2017. But Laura Owens will not let it go. He rejected her. And Laura Owens does not handle rejection well. And I think that is an understatement. Oh, so where is it? Here it is. Dun dun dun. Yeah. So here is the entire, the docket. 7/27/2026. I assume there's more. Documents will not be provided in this case without a formal request. This was filed 1204 by appellant, improper by herself, not a lawyer, in appealing order from 11/05/2025. And yeah, you can see she barraged everything. She barraged the appeals court with a lot of paperwork. But finally, 8/20/2026, yesterday, by the court on December 18th, 2025, L.O. Laura Owens filed in the Superior Court a designation of the record on appeal, including the following item: 15 minutes for November 5th, 2025 hearing, filed November 5th, 2025. However, no such minute order appears in the clerk's transcript filed in this court on March 19th. Therefore, on our own motion under Rule 8155A1A, we hereby order the Superior Court to augment the record with that document. Which basically is, clerk of court, put this document on the record. It won't change anything, but so it really doesn't matter. And order filed. This is the important thing. By the court on July 13th, Laura Owens filed a motion to augment and correct the record on appeal. In that motion, Laura seeks to add to the record written communications and supporting documents identifying the motion and authenticated in an attached declaration. That is Laura Owens trying to get into the record why she skipped. Yeah. On those hearing dates where the judge told Laura Owens, you have to be here. She got it postponed once, and then she simply didn't show up for the second one on November 5th. So the judge threw her case out. Now, Laura Owens' excuse is, oh, I was deadly ill. Which she always is when she's about to be exposed. She becomes deadly ill. So she tried to use that to get it postponed again. But here's the thing. No. And then she tried to have, well, I can give you authority to look through my medical records. No. And the court said, no, we really don't care. If you want to file something, well, they didn't say it out loud, but the underlying meaning was, if you don't file it, it doesn't exist. That's the gist of it. So, but she tried now via appeals court to force the Superior Court to add her story. Added to record, blah, blah, blah. Under Rule 8155, Subdivision A1 of our Rules of Court, we may order the record augmented to include any document filed or lodged in the case in Superior Court. However, none of those materials were filed or lodged in the case in the Superior Court. And Laura has adduced no authority for deeming them filed or lodged. None whatsoever. We therefore cannot augment the record with those materials under Rule 8155, Subdivision A1. Moreover, these materials fail to show any error in the making of the record, and because they were never part of the record below, they have not been omitted. In short, they are not the proper subject of a motion to augment the record. And yeah, a completely viable, reasonable decision from the appeals court. If you want it on the record, go to the Superior Court, file the proper things and try to have it. If they deny it, tough luck. Nor will we grant Laura relief by receiving those materials as new evidence under Section 909 of the Code of Civil Procedure. Under that statute, a reviewing court may take additional evidence in the interest of justice. The power to invoke the statute should be exercised sparingly, ordinarily only in order to affirm the lower court decision and terminate the litigation, and in very rare cases where the record or new evidence compels a reversal with direction to enter judgment for the appellant. Here, Laura is challenging a judgment entered against her at an ostensibly contested hearing where she was not present and no evidence were introduced. Yeah, Laura, you weren't there. You made up a medical emergency, and then you never filed anything. Assuming arguendo that the proffered materials offer her some help in the instant appeal, it still would not compel a reversal with directions to enter judgment for her. We therefore decline to exercise our discretion to take new evidence. That would be the appeals court saying to Laura, your information will not change the decision from the judge at all. Based on what you filed, Laura Owens, we agree with that the lower court should have thrown the case out, regardless of what you now claim is new evidence. So fuck off. No, they will not. The appeals court will never use the words fuck off in their filing, but sometimes you can read between the lines. Next, the motion seeks under Rule 8155 subdivision C an order directing the Superior Court to correct the minute order, documenting the hearing at which Laura Owens' case was dismissed, to reflect two alleged facts that are not mentioned in the reporter's transcript of the hearing. Regardless of whether such allegations provide historical context for what occurred at the hearing, they do not show that the minute order is incorrect and therefore in need of correction. In short, they are not properly the subject of a motion of Rule 8.155 subdivision C. The appeals court is telling Laura Owens, clock off. Hi, Swamp Bear. Yeah, hello, folks. Hey, Swamp Bear, Mr. Big Play, Gen X, Jeezer, Lisa B, Gwendolyn, Kate, and yeah, hello. And hello, you guys over at Rumble. Good to have you all here. Good to have you all here. Remember to hit the thumbs up, you know, the YouTube things. It does help. It does help. Finally, under Rule 8155 Subdivision A, the motion asks us to augment the record with respondents' April 29th, 2026 fee motion and its supporting exhibits, the May 7, 2026 withdrawal papers, and the procedural posture correction. But as MM notes in his opposition, none of these materials, Mike Maricini, none of these materials were before the court or could have informed the order challenged in this appeal. For that reason, we deny the motion with respect to these documents on the ground of irrelevance. Yeah, we could tell that Laura Owens was just spewing information that was completely unnecessary and irrelevant, and the appeals court thinks so too. So, denied! Laura Owens' July 27th request for leave to file a reply is granted, and we have reviewed that reply. The July 27th request for judicial notice is denied as irrelevant. Yeah, what Laura Owens did in her reply was to basically say the same things again. Unsuccessful again. Rules of Court Rule 8252, Subdivision A2A, and the July 13th, 2026 motion to augment and correct the record on appeal is denied in its entirety. That is the appeals court telling Laura Owens, you're a bad filer, and we're... Laura, it's not working out. We're breaking up with you. So, Laura Owens, and we went through this on my channel, her letters, and it's insanely stupid. But the sad part is she will not stop. She already said it. Regardless of this decision from the appeals court, she will go back to the Superior Court in California, in a state that she does not live, to file for a new restraining order. She will not stop. Now, one way of stopping her is to declare her a litigious, a vexatious litigant. Hopefully, that will be successful. Oh, I hope it will be successful. Because then, if I remember correctly, in California, if she is declared a vexatious litigant, she has to put a bond for the cost of the litigation. if I remember correctly. If there is a California-based attorney in the chat, correct me if I'm wrong, but I do believe they have to put up a fixed amount. I don't know, it might be $1,000, it might be $30,000, I don't know. But I do believe as is in many states, if you're declared a vexatious litigant, you have to be approved to file first, and even if approved, you have to put a bond up, which includes costs for the person you are seeking shit against. Yes, Jeff used to say, the court perhaps should say, off you fuck. That has a certain majesty about it. I agree. I absolutely agree. So, Mike Marcini met Laura Owens back in 2014, 12 years ago. He is now with spouse and kid and everything. Moved on. Hasn't contacted her in any way, shape, or form since 2017. But she will not stop. Sadly. She won't. Well, even if she is convicted in Arizona, or she takes a plea deal in Arizona, I don't think it matters to her. I really don't, sadly. That's just the reality of what I call a cluster B personality. She does it to people because she thinks she is the right to do it because they wronged her in her own mind, which makes everything okay for her to do back to them, including stalking, harassing a poor man for now 10 years since he broke up with her. It's absolutely insanity. That's an example of what she did to this poor man. After they broke up, they still had some business relation together. He was scheduled to fly to Iceland. She told him she wouldn't be there, and he must have thanked his lucky star. What did she do? She surprised him on the airplane. And poor Mike had to lock himself into the airplane bathroom to get away from her, as she faked sobbed, and then he had to endure her on Iceland, where she claimed that he assaulted her, which is absolutely false. Here's the thing, what you might not know about Iceland. About 15 years ago, the Icelandic women came to an agreement that no, none of us will go to work until the politicians do what we say. I don't remember the actual issue. And they all did. Almost everybody went on strike. All women. If she had been assaulted, as she claimed, on Iceland, and anybody have seen it in Iceland, there would be an absolute uproar. There would be every ounce of help guided to her. All the 50 cops on Iceland would have been on the case. And the reason why there was no case on Iceland is because it never happened. She lied about that too. Laura and JLR would make a good. I don't even know. I don't want to imagine that. And thank you, Derek, for 80 joules. Clock it. Yeah, Thank you so much, Derek. And thank you, Derek. Derek is also a monthly, what do you call it? Who's a monthly supporter via PayPal. And yeah, so which is an alternative for, I assume, YouTube membership. Sadly, that doesn't mean that you get access to YouTube perks. But it is an option because as you know, YouTube takes 30+% of everything that is donated to this channel here on YouTube. So if you want to allow me to keep more of it, use PayPal or buy me a coffee. That is around 5%, I think. I have to grift a little bit, a little tiny bit. So yeah, that is. I mean, there's so much about the Mike Maricini case, and I have on the playlist, on the Laura Owens playlist. You can go watch it. There's a lot of it, or you can go to the webpage Victims of Laura Owens. .com, victimsoflauraowens.com. They have everything there, every document. They have videos. They have the court case between Clayton Eckert and Laura Owens, all the hearings. So you don't actually have to watch me to get that information. You can go directly to victimsoflauraowens.com. Now, folks. Oh, I have to swoop. Hold on. Swoop. Where's my swoop? There's my swoop. That, my friends, is the Norwegian fire-farting dragon. You cannot sneak up on that from behind. All right, now to the almost the star of the show. Dun dun dun. You remember I mentioned that there was a case between Clayton Eckert and Laura Owens. Mike Maricini was subpoenaed as a witness at the trial, at the family court trial. So he kind of have to. He's subpoenaed by Clayton Eckert and his lawyers, so he shows up. What Laura Owens' attorney, David S. Gingerass, or as I effectively... Folks, let's just say this. A while ago, David's estranged wife passed away. That is why you have heard absolutely nothing on this channel about him for months. Now he's back. And he takes up where he left off. Which means, okay. And through a common acquaintance, I have said, I will leave it. If he actually says, I'm done with all of this, with lawyering and all of it, I will leave him alone. But now he's back. So, this, what we are going to listen to, is David S. Gingerass 911 call, trying to get Mike Maricini arrested for violating the restraining order, while Mike Maricini actually had a valid subpoena. He had to be there. So let's do this. Dun, dun, dun. And a huge thank you to Schnitzel Ninja who uploaded this 911 call. Everybody go subscribe to Schnitzellinia for every news possible around the Laura Owens case.
Schnitzel Ninja.
Phoenix 911, what is the address of your emergency?
Hi, I'm at the Superior Court on 40th Street and Union Hills in Phoenix. I can get you the address in a minute, but I assume you can look that up.
Okay. What's going on?
I'm an attorney, and I'm here with a client who has a domestic violence restraining order against an individual. The individual is here in violation of the order.
Line number 1. That is an attorney making a false allegation on a 911 call. Mike Maricini had a valid subpoena. And here's something. He made this 911 call after they went into the judge's chamber, where the judge told him directly, no, Mike Maricini does not violate the restraining order. He is here on a valid subpoena. David knew this. Now, he might not agree with it, but not agreeing with a court order doesn't make it that you can do this. The court told him, the judge told David before this 911 call, no, Mike is not in violation, because this is not the only time David tried to have Mike arrested. He tried with the courthouse security. They more or less told him to clock off. And he still made this call trying to get Mike arrested. Probably, allegedly, because David and Laura was scared shitless about what he could testify to in that trial, that family court trial. Because Mike Maricini on the stand could have testified about everything he went through with Laura Owens. Now, since they only had a 4-hour trial, they didn't have time to call Mike to the stand. And it wasn't needed because Laura Owens took the stand and got herself into trouble. Her taking the stand, lying her teeth out, is probably the reason why she is facing criminal charges, 14 felony charges. But let's continue listening.
The client is scared to death. He's been making threats towards her, and we'd like someone to...
Line number 2. Mike Maricini has never contacted Laura Owens. He has barely spoken about Laura Owens. He's been on live stream talking about what he went through, but he's never... And not even David, in all of his filings, has a single quote where Mike has actually threatened Laura Owens. Not one. So here he is, line number 2 on a 911 call. David should be really glad. Thank his lucky star. Because false reporting is a crime.
come out and enforce the court's order.
So 18380 North 40th Street, sound right?
Yes.
Superior Court. And do you know the client's name?
Yes.
And her birthday, do you know?
Yeah, in the release 911 call, of course, they are redacting names and social security and birthday and stuff like that. Now we already know it because she kind of have to tell the court when she is in a hearing, when she is at trial. I will not repeat it. I will just tell you guys. She says it herself on court proceedings.
Okay. Do you know if this has been served, this order?
It has. Absolutely, it's been served.
So is he supposed
Yeah. He still hasn't said it's in California.
to be there or no?
He is not supposed to be here. He does not have permission to be here.
Line number 3. As I said earlier, the judge in Arizona told him to his face that Mike Maricini has a right to be there because he has a valid subpoena. Told him to his face. So this is line number 3 in a phone call that so far has lasted 1 minute.
Okay, so this is for...
Correct. Party. The restrained party is a different individual, and I have his information here.
Can you please give me his name?
Yes. Last name.
And his birthday?
Date of birth.
Okay, where is he at right now?
He's in the hallway. He's about 20 feet away. My client's locked in a room because we had court security put her there. She's absolutely.
She claimed, "Oh, I need to be in here, and because I'm deathly afraid." She is not afraid of him, not one bit. What she's scared of is him exposing her by testifying.
Absolutely scared to death. But the guy's here in the courthouse somewhere.
Do you happen to know the case number?
I do. I don't have it in front of me. We're here in front of Judge I have a case number here, if you're ready. This is not the case number for the restraining order. The restraining order was issued out of California.
Now is the first time he said, "Oh, the restraining order is out of California." Okay? So you can hear that the 911 operator almost, okay, something's fishy here. Restraining order out of California. He is in the courthouse in Arizona, and there's a case in front of Judge Mara.
It doesn't make any difference.
Yeah.
I have a case. I have both. We're here on a paternity matter that this too.
He's not a party to this restraining or to this matter, but he's there.
He's there. He's here.
Okay.
Now he's omitting the fact to this 911 operator. He only says he's there. He knows he's a witness. He knows he has a valid subpoena. So 3 lies and omitting crucial facts.
Sorry.
He's claiming to be a witness, but he does not have court permission to be here.
Line. Okay. Now finally he says he claims to be a witness. No, he doesn't claim he's a witness. The court says he is a witness with a valid subpoena. With a valid subpoena, you don't need the California court's permission, which was explained to him in that room in front of the judge.
Not from the California court.
Yeah, so he's not involved in court case today, right?
He's trying to be involved, but he's not allowed to be. The court order does not allow for any contact whatsoever, including.
Again, okay. 3 lies, 2 omitting facts. The court order does not allow for any contact, which is negated by the fact that he has a valid subpoena, which David knows. So the thing that he tries to is false as well. Okay, so 4 lies. No, he is subpoenaed to be there.
In court appearance.
Including in court appearance? How? I mean, every second word and in combination are complete fabrications from David Gingerass.
Sorry. Alrighty. So his ID would be out of California?
Correct.
Okay.
And I have a copy of the order in my hand right here as well. So.
And is he white, black, Hispanic, Native?
He's white, about 6'4".
And how, like, thin, medium, heavy built?
His weight is listed as 220 pounds, 6'4", feet thin, I guess.
6'4", 220. I don't think that's thin. So Mike and me are the same height. I'm 290. When I was 220, it was 25 years ago, maybe, or 30 years ago. I was not thin. So, seriously. I mean, the amount of bullshit here is staggering.
Do you remember
Brown hair,
which shirt he had on?
I don't. I only saw him from a distance, and it was brief. But my client saw him and immediately sort of ran into hide.
Has he ever been known to carry weapons, as far as you know, with your client?
I don't believe so.
Okay.
I think he can't. I think the restraining order prevents him from. Oh no, it does say no weapons, but I'm not aware of any weapons at this time. He came through court security, so that shouldn't be an issue.
At least David knows enough to not lie about that, because if he had claimed that, now we are into swatting territory. Now he's only trying to get him arrested. But if he, by any chance, had indicated that Mike was carrying, now we're into swatting territory. Which let's see, what's the penalty? Zona swatting. Let's check here. Dun dun dun. Let's see here. Yeah, it is illegal according to the Arizona legislators to SWAT, or as they express it, use of an electronic communication to terrify, intimidate, threaten, or harass, unlawful use of electronic communication device, applicability, classification, definitions. So this goes on. Swatting goes under that one. It goes under terroristic threats. It seems in Arizona. Let's see here. What would be the penalties? In Arizona, the penalties for swatting range from a class 1 misdemeanor to a class 6 felony. Class 6 felony triggered if you falsify a serious emergency involving an educational institution or place of worship. Okay, so that's not it. Class 1 misdemeanor. Triggered for generally false reporting of a bomb, fire, or emergency. Let's see here. Dun dun dun. Yeah. Depending on the outcome, apparently. Well, it can escalate to federal charges, or if the person dies because of the swatting call, that would be felony murder. So it's all the ranges. So David at least was smart enough to not indicate that Mike was carrying a gun. So, but again, it's so much, and it's all bullshit.
All right. Do you know what it was for, or what kind of threats he was making today?
Just to be here, just to terrorize her, I guess. He's not allowed to have any contact with her. It's not an order that just says no threats. It's an order that says no contact whatsoever.
Okay.
Generally, well, now we know, but the operator doesn't know that he had a valid subpoena, that Mike had a valid subpoena, and the court told David, Mike has a valid subpoena. You can't get him out of here, and he still tried. So I would actually regard this as a swatting attempt, not the most serious ones, but still, it tries to get him arrested, trying to get him into trouble, trying to get him put in jail in Arizona. He should thank his lucky fucking stars that he wasn't reported for it.
Do you know where he is now?
I don't. He should be at or near Judge Mata's courtroom. I think it's courtroom 101, possibly.
Okay.
He's in the north side of the building. He's within, the order requires him to stay 100 yards away, and he's certainly within that.
Okay, so I have a lieutenant asking if there's any way you can go up to the security guards there, because this is an MCSO jurisdiction. Do you know anything about that? Is there any way?
I just talked to the sergeant. I just talked to the sergeant here.
Yeah. So this is after the sergeant told him to fuck off. He tried to make this police report and have the police go in there. After the judge told him, no, Mike has a valid subpoena. After the court security told him to fuck off, he still tried to get him arrested via police.
And he said calling 911 is the right protocol. So I don't know. I mean, the court security here, I believe, are sheriff's deputies, but I could be wrong. But he said call Phoenix PD because we're in the city of Phoenix.
Okay. What was your name?
My name is.
Last name?
Now, if all of that would be correct, that this is what the sergeant actually told him, he could easily subpoena an affidavit, a testimony from that sergeant. Guess what? He hasn't, to my knowledge at least.
Are you still there with the MCSO? If you could just confirm that with them, because they're driving right now, but I just want to make sure that this is accurate.
Yeah, hang on a second. I'm just looking for somebody. There's a sergeant here I was just talking to. I don't know where he went. I'm literally standing at court security.
Okay. Can you just ask them if this is MCSO jurisdiction, if I need to bring them on?
Hey, there's a sheriff's deputy right here. Sir, I'm on the phone with 911 talking to Phoenix PD. We have a guy here who's violating a restraining order, and she's asking whether or not MCSO can help or whether the Phoenix PD. No, you're shaking your head. Yeah, it's Switzerland. Okay. Sheriff's that's a Phoenix PD matter.
It is? Okay. All right.
Yep.
All right.
You?
One sec.
Now, I would assume, I don't have the information, that court security already knows at this time that this is bullshit.
I'm sorry, you said which courthouse was it?
40th Street in Union Hills.
No, the courtroom, sorry, that he's going to be near.
I believe it's courtroom 101. It's just,
Yeah, Judge Maras.
it's on the north side of the courthouse. There's not that many. There's only like 2 or 3 courtrooms in there.
Okay. Okay, all right. Well, then they're coming in right now. David, if you could just step outside and meet the officers.
I will do that right now.
Okay.
Okay, thank you very much. Thank
All
you.
right, thank you. Bye.
Schnitzel Ninja.
Yeah, and the result of this was cops told him to fuck off. David Gingerass, in the case of with Laura Owens, have produced, in my opinion, so much hurt. So much hurt. And now I do know that Laura Owens sometimes tunes in to the coverage of her cases. Laura, your only defense in the criminal matter, if you don't take a plea deal and lets this go to trial, is to throw David Gingerass under the bus. Because if you got bad advice from David, while David knowingly had, because David had all the discovery, he had access to all the materials you had, Laura, then he knowingly allowed you to take the stand and perjure yourself. So Laura, if you're here, that's your only chance. Your problem is you're a proven liar. So the jury might not believe you anyway. But it would be funny. It would be funny. Yeah. Folks, this is a saga that will not end soon. Even though her criminal case is ongoing, she's managed to postpone it a bit, claiming that there might be a plea deal going on, or there is plea discussions going on. I don't think she has it in her to take a plea deal, because that would be admitting she lied. That would be admitting she tampered with evidence. That would mean she would have to admit of forging evidence. That would mean Laura Owens have to stand up in court and admit that she stole the story from a grieving mother who actually lost one of the twins in her belly. She not only stole the story, she stole her sonogram and presented it as Laura's own. That woman saw Laura using her last evidence, the only evidence that child existed. She saw her steal that. She saw her forge it. And she saw her lie about it. If that woman takes the stand in Laura Owens' criminal trial, the jury might ask the court permission to send Laura away for life. Because that woman's story is absolutely heartbreaking. And it shows everybody to what extent Laura is prepared to go to manufacture, forge, perjury to get back at somebody she believed wronged her. Laura Owens is what Amber Heard would have been if Amber Heard wasn't rich and famous. Laura Owens is a less dangerous version of what's her face? Sarah Boone. She is at the moment a less dangerous version of Sarah Boone. All of these cluster B personalities, and Laura Owens, I believe, is one of them. We don't know what she is prepared to do, because she has shown that when we think she can't steep deeper to a more, when we think she can't be more vile, she proves us wrong. So I honestly don't know where her vileness and evilness, where it has an endpoint. All right, folks, that was the update on the Laura Owens case. A little bit more information for you to know about exactly what type of person she actually is. Once there's new information, of course, I will keep you updated. And yeah, I'm going to send you over to my next stream, which starts 5 p.m. Eastern. It is the Slightly Buzzed show. And today we are going to talk about Rick Allen. Rick Allen is wrongfully convicted. His case is up for the Indiana Appeals Court. And we are going to talk about Rally for Rights, Rally for Rick. They are organizing a rally for Rick on September 21st. So one of the organizers will be a guest. I will have other guests on because we will also talk about leading up to the live streamed appeals court oral arguments on September 21st. I will be in that courtroom if I can get in. I will travel to Indiana on September 10th, and I will visit Delphi, Indiana. I will visit Hamlet, Indiana, and I will visit Flora, Indiana for other cases. But mainly I am there because Rick Allen was railroaded. He was framed. And if I can help in any way, shape, or form to make people understand that Rick Allen is actually innocent, I will spend my hard-earned vacation days on traveling to Indiana. So tune in at 5 p.m. Eastern Time and learn more about the Delphi case, Rick Allen, and what we can do to help Rick Allen. All right. Thank you so much for tuning in. I will see you in 3 hours. Bye-bye.
Santa Claus, riding in with the winter law.